Hello and welcome to my channel. Today I'm going to help you understand some important topics on data governance and the Cloud Act. Data residency, data sovereignty, and data localizations are three interrelated concepts in the realm of data management and legal compliance, especially in the context of cloud computing and international data transfers. I'm going to break down these topics in simple terms to help you understand while preparing for the cybersecurity exams. Data residency refers to the physical or geographical location where an organization's data is stored. The decision to store the data in a specific location can be influenced by factors such as performance, cost, taxes, and the legal or regulatory environment. For example, Microsoft operates a data center campus in Dublin, Ireland. This residency is influenced by various factors, including Ireland's favorable corporate tax environment, skilled workforce, and access to the EU market. Data residency is primarily about where the data is physically stored. The next concept, data sovereignty, means that the data is subject to the laws of the country in which it is physically stored. This means that regardless of where the data is collected or who owns it, the data must adhere to the legal requirements of the country in which it is physically stored. For example, if Microsoft stores an Indian citizen's data in Ireland, in that case, the Indian government would typically not have direct legal rights over this data under standard circumstances. The data would primarily be governed by Irish law and GDPR, which might limit its accessibility to foreign governments, including India, without appropriate legal processes. Data localization or data residency law mandates certain types of data to be collected, stored, and processed within a country's borders. Countries limit such data flows in multiple ways. In some cases, an organization must store a local copy of all data, even though this data can be taken and processed outside the country. This is usually to enable the relevant government to audit its own citizens' data. Russia's data localization laws require that the personal data of Russian citizens be stored within Russian territory. This means that multinational companies such as Microsoft must have data centers in Russia to store and process the personal data of Russian citizens. This requirement is a form of data localization where a country mandates that data about its citizens or residents be stored and processed within its borders, often for reasons related to privacy, data protection, and data sovereignty. To summarize, data localization, data residency, and data sovereignty are terms that are sometimes used interchangeably, although they have slightly different meanings. Data localization laws require sensitive data to be collected, processed, and stored in the country of origin. Data residency refers to the place where data is physically stored or processed. This is usually for legal, tax, or policy reasons. Data residency must comply with data localization requirements, wherein the organization must store the data in the country of origin. Data sovereignty is the principle that the data is subject to the laws of the country where the data physically resides. These concepts have significant implications for multinational companies, especially in terms of compliance with varying international laws, the cost of data management, and the complexity of operating global IT systems. These concepts are becoming increasingly important in the global digital economy as they impact how companies manage their data infrastructure and comply with different jurisdictions' legal requirements. The case of Microsoft Corporation versus United States, often called the Microsoft Ireland case, was a significant legal case involving data privacy and law enforcement access to data stored in cloud computing services. This case played a crucial role in international law and data privacy and eventually led to the enactment of the Cloud Act. Origin of the case. The case began in 2013 when the United States government issued a warrant to Microsoft under the Stored Communications Act (SCA) of 1986. The warrant demanded emails related to a drug trafficking investigation. The emails were stored in a data center in Dublin, Ireland, operated by Microsoft. Microsoft's challenge. Microsoft complied with the warrant for data stored in the US but challenged the warrant's applicability to data stored in Ireland. Microsoft argued that the US courts could not compel American companies to produce data stored in servers outside the United States. Legal proceedings. Initially, a U.S. magistrate judge ruled that the warrant was valid, and the U.S. District Court for the Southern District of New York upheld this decision. Microsoft then appealed to the Second Circuit Courts of Appeals. In 2016, the Second Circuit ruled in favor of Microsoft, holding that the SCA did not authorize U.S. law enforcement to access data stored outside the United States. Implications and reactions. The case garnered significant attention and reactions from technology companies, privacy advocates, and governments worldwide. It highlighted the complexities of jurisdiction and law enforcement access in the age of cloud computing. Tech companies, particularly those offering cloud services, were concerned about the implications of the case for user privacy and international business operations. While the case was pending before the United States Supreme Court, the U.S. Congress passed the Cloud Act in 2018. The Clarifying Lawful Overseas Use of Data Act, better known as the Cloud Act, is a U.S. federal law enacted in 2018 designed to address and streamline the process of accessing electronic information across international borders. The Act has significant implications for law enforcement, privacy, and international cooperations. This law allows federal law enforcement, such as the FBI, to compel U.S.-based technology companies, such as Microsoft, via subpoena or warrant to provide trans-border access to data regardless of whether the data are stored in the U.S. or on foreign soil. This is a significant change from previous legal standards where accessing data stored abroad was more challenging and often mired in legal complexities. This broad reach has led to apprehensions about the potential for overreach and intrusion into personal privacy. The Cloud Act acknowledges the importance of respecting the sovereignty and legal frameworks of other countries and does not supersede, ignore, or change another country's local laws. The Act also provides mechanisms for service providers to challenge data requests that they believe are not legally valid or that conflict with the laws of the country where the data is stored. The Act allows the U.S. government to enter into executive agreements with foreign governments, which can streamline the process for these governments to request data directly from U.S. service providers. However, negotiating these agreements can be complex as they must balance law enforcement needs with citizens' privacy. Complying with the Cloud Act requests could potentially put companies in violation of the GDPR, particularly if the data transfer does not meet GDPR standards for international data transfers. Companies faced with conflicting demands from the Cloud Act and GDPR may end up in legal disputes, having to navigate the complex interplay of US and EU laws. The Cloud Act has been both praised and criticized. Proponents argue that it is a necessary tool for law enforcement in an age where digital information is stored globally and is crucial for investigations. Critics, however, raise concerns about privacy, the potential for abuse, and the implications for international norms of data access and data sovereignty. The Act represents an attempt to balance the needs of law enforcement with privacy and data protection in a global digital environment. I hope this video helped you understand data governance concepts such as data residency, data sovereignty, data localization laws, and the Cloud Act. If it did, please click on the like button below and subscribe to my channel for more cybersecurity content.